Good morning. Happy Friday, everyone. Glad you all could join me on this fine Friday morning for day 5 of the Laurie Shaver trial. She is on trial for the murder of her husband, Michael Shaver, and we have gone through quite a few witnesses. The defense, I believe, wrapped up yesterday, um, and that wrapped up with not only a testimony from Laurie Shaver's daughter, Isabel Shaver, but we actually heard from the defendant yesterday, and she spun quite the tale that is totally inconsistent with all of the other evidence that we have heard through this entire case. The prosecution put on, let's see, 32 witnesses, and the defense has put on 5. I believe the defense is done. They may still be going this morning. I don't think so. But even if they are done, the prosecution still is allowed to call rebuttal witnesses. So we will probably hear from some rebuttal witnesses this morning. Hey, Miss Carol, how are you doing? Good to see you here. So before we get into closing arguments, we are definitely going to hear from some rebuttal witnesses. Uh, I am just going to get right into it this morning. We're not going to have any previews, no sideshows this morning. We're just going to jump right in. Yesterday, we were able to go at a pretty good clip when we put it on 1.25 speed. So I'm going to keep it on 1.25 speed today. If you all have any trouble hearing what's going on, please let me know, and I will put it back on single speed. But for now, let's get into it, see what everybody has to say today.
Some of this data, Judge, that I tailored for the board.
But the states is a standard instruction, correct?
Mine's a standard instruction.
Okay, so let's look at the states, and if there's something you would like to add, then please raise that as we get to the appropriate portion of the instruction.
So it looks like they are arguing over jury instructions at this point.
So the states, paragraph number 1, any issues?
I think that's the standard there, Judge.
All right. So we're moving on to Laurie Shaver was justified in using or threatening to use deadly force if she reasonably believed that such force or threat, that those 3 paragraphs.
When I put Laurie Shaver, I put in it, Laurie Shaver was oh, wait a second. That Laurie Shaver does not have the burden of proving.
So I don't think we need to listen to them argue over the jury instructions. We are going to hear the judge read the jury instructions that they decide upon later in the trial when the jury is charged. So let's just try to skip through these jury instructions and get right to the testimony.
That's okay.
Any issues there?
No, sir. As I stated, Earhart declares that you can't establish reputation within a home.
He's conceding that there's no reputation evidence, so these 2 reputation paragraphs should be taken out.
No, I'm saying they should be taken in.
And once again, the paragraph that precedes the ones we were talking about, the 2 paragraphs that we precede that we're talking about, if you find that Laurie Shaver, because of threats or the prior difficulties with Michael Shaver, had reason.
All right, so this is about where the testimony is going to start.
Please come up to the witness stand. Good morning. All right, please be seated and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus.
Okay.
Rena is R-H-I-N-A, McManus, M-C-M-A-N-U-S.
Thank you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And have you, yesterday or during this week, viewed any broadcasts of the trial?
No.
Okay.
Only like during the weekend when they were picking the jurors on the news, but
So only over the weekend, okay? But no picking or selecting of jurors occurred over the weekend. That began on Monday morning, okay? But so you did view some broadcasts regarding the case prior to trial.
Just listening to that they were going to pick and this was going to happen, but that's it.
Okay. And did you go on social media and post anything concerning the case?
No, sir.
Okay. Did you view anything about the case on social media?
No, sir.
All right. Does the state wish to inquire?
Ms. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just like, I'm sorry, just stating news over like Channel 9, stating that like there was a trial going to begin and that's it.
There has been live stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified this week?
No, sir.
Mr. Wiggs?
The rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration.
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here. You may approach.
McManus?
Yes, sir.
This shows communication on a date specific at the top of this, and communications transpiring, correct? And your name is on that document,
Then here, sir?
correct?
Yes.
Okay, and there's discussions about the case on a particular date referenced from this communique, correct? So while this court case was open and the rule had been invoked, there was to be no discussions by any witnesses and no review of social media. When did you look at this?
I did not, sir.
Okay.
But my,
Let me ask, why does it have your name on it?
because my daughter and my husband, they all use my phone.
Okay.
But I did not, because I got an email from somebody from the state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday, something like that.
And you have abided by that.
So defense counsel is kind of stuck here because remember his theory that he's been putting forth all this time is that somebody else was using Laurie's phone or Michael's phone or Laurie's Facebook account or Michael's Facebook account. And now this witness is saying, no, somebody else was using my login on my phone. And so it appeared as me. So I don't know how he's going to try to get this witness kicked, this testimony kicked based on the fact that he's already conceded that this is very likely to occur when people live together, right?
By that request, correct?
Yes, sir.
Okay. All right.
I think that's sufficient, Judge. I mean, the state wants us to assume just because there's an internet browser in this household, nobody else had access to it, and nobody else could enter that same site. That's the inference they want to inform the jury about. I'm not satisfied. I'd ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse? Is there going to be any more inquiry, Ms. McManus? Should we excuse?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to review documents. He may have some additional questions.
So Wiggs just basically said it's the state's position that nobody can use anybody else's stuff. And that is not the state's position. The state has been very clear, even asking their own expert witness regarding the electronic equipment. They've been very clear and consistent that other people can access certain IP addresses. They can access people's accounts. They can do all of those things. They just call into question whether that actually happened in this case. So the Wiggs is trying to basically say, look, the state has been saying all along that you can't access other people's stuff. So I don't accept what she's saying about her having other people in her house having accessed her stuff.
I don't know.
11:55 this week, correct? Wednesday, 11:55 this week, correct?
11:55. I don't know. I do have my phone and I can. I don't.
My client has her phone record showing that. Judge, I don't, but we know it's during this week time. That's when we found it and discovered it. She's acknowledged that people within the household, she declares, were using her phone. I'm not satisfied with that. Yes. And my client has her phone records.
All right, and Ms. McManus has testified under oath that it was not her, but a family member.
Right. That doesn't seem to jive with the state when my client testifies to those same facts, Judge.
Is there
This witness isn't on trial for her freedom, so she doesn't have a reason to lie. Your client has a very big reason to lie.
any more inquiries from Mr.
Anything further, Mr. Wiggs?
No, thank you.
You may step down from the witness stand. Thank you.
Your Honor, I do
Please
have.
remain outside the courtroom.
So the court generally does not assume and generally can't assume that people under oath lie under oath, because if we begin to assume that everybody who's under oath lies when they're under oath just because we happen to think something different might have happened, then the whole judicial system breaks down, because our judicial system relies on the notion that once a person takes an oath, that they are going to tell the truth, they actually do tell the truth. Without that that underlying principle, without that underlying belief, there's no point in putting any witnesses on the stand in any case. So the court here kind of has to believe that the witness told the truth here.
Courtroom.
I do have the Florida Statute 90.616, which deals with rules of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense of the court. The rule of sequestration only extends to the viewing of testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly.
So the reason that it only applies to testimony, one of the big reasons it only applies to testimony is because you can't tell a juror, don't watch the news, don't watch the weather report, don't watch the a witness, don't watch the news, don't watch the weather report, don't find out what's going on in your community, just turn your television off, right? Just in case something comes up on the news about this trial. We don't tell witnesses to do that. So if a witness is watching a news program and something about this trial happens to come on that news program, it's kind of a known quantity at that point. We know that this is going to happen. But you're not allowed to go watch court TV, right? She was watching court TV. So everyone's aware, court TV, to my knowledge, has not broadcast this trial. They have broadcast snippets of this trial, but they're mostly doing interviews about this trial. So on their online live broadcast, they're not doing this trial. So I doubt that she was on court TV watching the trial itself. It sounds like she was on court TV in one of their chat rooms where they were interviewing somebody, because they have interviewed people about this trial, and she made a comment there. Or if believing her testimony, one of her family members made a comment there. So let's see what happens.
This is from Head Notes 1 and 2. Appellant correctly argues that the trial court erred when it applied the sequestration rule as a strict rule. A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation of the rule. Should determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion in deciding whether or not exclusion of the witness is necessary. In this case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question, and she's just going to testify about the child's demeanor, and that there was never any period of time where there was any sort of change. And also I have the school records of Isabel showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case, whether or not she or someone in her family liked a post about the case, does not warrant exclusion in this case.
All right, Mr. Wicks.
To the court, Judge, the data, the information she's looking at is court TV. It's not just a little blog from one person to another. The heading directs that she's observing this, but that she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witness has violated the rule, then she should be excluded.
The motion to exclude is denied. As to Ms. McManus. Now we're on to Ms. Urbanowski.
I don't recall defense counsel having raised a prior objection regarding Ms. Urbanowski. I do recall them
Good
making a
morning.
prior
Please come up to the witness
objection
stand. Please be seated. Make yourself comfortable. And let
regarding
me know when you're ready to proceed.
McManus. Urbanowski is Laurie's friend, I believe. I believe this was the woman that lived with Laurie for quite some time, and her personal trainer, if you
We all
recall
set?
the testimony.
Okay. Please state and spell your full legal name.
My name is Rebecca Urbanowski. It's Rebekah. Last name is Urbanowski.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes. A business and a personal. Yeah.
And there was a reference, I believe, it might have been like on a post with your Facebook profile liking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like a post such of that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs.
Have you been looking at court TV?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, it's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, it's me.
And that says court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Yeah, we heard different from your husband this week. But this would have been Wednesday at 4:37 this week?
Okay.
Is that correct?
If that's what it says.
Is that correct? You think?
I
You don't know? Okay. So we'd ask these to be admitted into evidence,
It's fine.
and because of the personal nature,
Or as far as the hearing goes, fine.
All right.
because,
I don't believe her. I think she was on court TV.
yeah, correct.
So admitted into evidence as to the hearing only, not as to the trial. And what exhibit are we up to?
I think this would be Exhibit 1 for purposes of the hearing.
Purpose of the hearing, it'll be a composite of 3 documents. It'll be Defense Exhibit A. It'll be entered into evidence without objection as defense number 1 for the purposes of this hearing only.
I don't have any further questions this morning to the court.
All right, and please proceed. Further questions?
Further questions?
Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr. Wiggs.
Because of the sensitive nature of the case and the clear instructions of the court to every juror and the obligation of the state, and this matter has proceeded more than once throughout the trial, the state has had ample opportunity to
So the state just told everybody, including defense counsel, here's the standard that Florida courts go by in determining whether or not to not permit a witness to testify if they have violated the rule of sequestration. And that standard is based on whether the court believes that the testimony that they are going to offer will be altered significantly by their violation of the rule of sequestration. Mr. Wiggs did not ask very many questions of this witness. So if the court holds him to that standard, then I think it's going to be difficult for Mr. Wiggs to demonstrate that Ms. Urbanowski's testimony is going to differ significantly based on her having looked at court TV on Wednesday. But we'll see.
You properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at that. They don't look at anything. This woman was not responsive and not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony of the case. That is what would invoke the rule of sequestration in the inquiry, and there's been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed, so therefore the request should be denied.
Motion to exclude is denied.
So do you see what the prosecution just did? He said, look, he had an opportunity to ask questions about whether or not she viewed this material. He failed to ask that question and get a definitive answer from her. He had the opportunity to ask her how her testimony might be altered by viewing it. He didn't ask any questions about that. He has not satisfied the standard. I told him the standard before this lady took the stand, and he decided not to ask any questions about it. The prosecution did a brilliant job here.
Is there anything further before we call the jurors back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the jury in. Thank you.
So, Carol, you asked about the Miss Urbanowski. So remember, she's married to Mr. Filmer, and there was a witness who said that he talked to Rebecca, and that's when he decided that he was going to call the police based on that conversation. But he wasn't allowed to say what happened in that conversation. So if we're about to hear from Rebecca, I would venture to guess that she's going to be testifying as to what that conversation was that prompted someone to call the police and investigate this whole thing in 2018. And remember, she was living with Laurie back in 2015, 2016, somewhere around there. So she probably got a lot of information that the defense doesn't want to get out there.
Please be seated. I see that all of the members of the jury have returned. Thank you again, members of the jury, for your time, attention, and patience today. And I have a few questions for you before we begin. Did any of you speak with anyone or each other about the case? Okay, everyone has answered no. Did any of you view any media, news reports on the internet, anything about the case? Okay, everyone has answered no. Did any of you conduct any research concerning the case? All right, all jurors have answered no. Did any of you encounter or speak with any of the attorneys who are present in this case? Okay, all the jurors have answered no. Anything further from the defense or the state? All right, then the defense has rested. State, you may proceed.
The state calls Rena McManus.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus, RHINA MCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach then?
First grade.
How old are students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And how did you know them?
I had met, they were parents of Isabella, obviously, but I had met them both meet the teacher that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time?
Normal parents, inquisitive about how the year would be, wanting to find out about me and the curriculum. It was very pleasant.
Now, over the school year that you were dealing with Isabel Shaver, did she have good attendance?
Yes.
Good grades?
Yes.
And did you ever notice any issues with her?
No.
Was there any time that you saw some sort of behavior change in her?
Not at all.
Any time where she appeared to become more withdrawn or acted in a different way?
No.
Going to go ahead and at this time admit records, school records of the children, showing defense states MMM for identification. The state moves into evidence, states MMM as the next numbered exhibit, as a business record with the proper business.
For those of you who don't know, teachers are supposed to keep track of things like behavior changes, things that might indicate that there are problems at home, because they're one of the people who are kind of charged with calling the Department of Children and Families or reporting suspected unfit parenting, abuse, neglect, things of that nature. So the fact that she didn't notice any change in any behavior in a 6 to 7 year old who had just killed their father is a little suspicious.
For business record certification and notice.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
All right, without objection, states MMM will be admitted into evidence as states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Ms. Shaver while she was in your class.
Yes.
And does that confirm everything you've been saying about attendance, grades, no behavior problems, things like that?
Not at all. Yes, it does.
Throughout your teaching experience, do you encourage students to talk to you if they have any sort of problems?
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers. Sweet.
Nothing further, Judge.
All right, thank you, Mr. Wiggs.
How old was Isabel?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're talking about the mindset of Isabel Shaver, correct?
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct?
Correct.
Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up. They may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
Okay. How large is your class?
It goes from like 16 to 20 students.
How many sit-downs did you have with Isabel Shaver on a one-on-one?
Many.
Any?
Mostly, it's all academic, so we do small groups.
No, I'm not talking about a small group. I'm talking about you on one-on-one with Isabel Shaver.
In what manner, sir?
I'm just asking you, did you have any one-on-one sit-downs with Isabel Shaver?
In processing education, the way we teach? Yes, sir, I did.
You sat with Isabel Shaver individually, without anybody else around.
That's not what I'm understanding.
I don't know.
No, I have
What?
never.
No, ma'am. Let me ask.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do, I'm just bringing that point out. You didn't do that.
I think you should care about what I do because I'm a teacher.
Ma'am, I'm bringing out a point.
Okay, sir.
You're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree to do that, correct?
No, sir, and I would not.
Correct.
Thank you.
All right, state.
Mr. Canis, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
That should be released from our subpoena.
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
The state calls Jared Strickland.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Good morning.
This dude has got to be sick of testifying in this case. This is the third time we're seeing him on the witness stand.
All set? Okay. Please state and spell your full legal name.
Jared Strickland, Jarrod,
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, Lake County Sheriff's Office.
We've been having various discussions about Facebook profiles. The last section I want to cover with you did you view various pictures of Laurie Shaver's child, Isabel Shaver, from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing the fence was previously been marked for identification as states NNN. Showing the witness was previously been marked for identification as states NNN. Do you recognize those photos?
Yes, I do.
And are those photos from the Laurie Shaver Facebook profile that's already in evidence?
Yes, they are.
All right, this time the state moved NNN into evidence as the next number to exhibit.
All right, that would be 66. Any objections?
Yes, Judge, a standing objection as to the motion regarding digital data and the relevance issues we've raised previously.
All right. The objection is overruled. States NNN will be admitted into evidence as states number 66.
And Detective, it's easier to just reference the posts from the packet I gave you. Go ahead and publish. Good for you guys. All right. So this first photograph that we are looking at, when was that posted?
November 18th. Actually, November 16th, 2015.
So approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post. When was this photograph posted?
November 21st, 2015.
We have a series of, I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
November 22nd, 2015.
And that would extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
don't know if I'm in order. I see the screen.
Yes. This photo here is part of that same April post, right?
Yep, there it is. I believe that those are, or the dates are out of whack. It looks like the end of March 2016.
And then the photos here, first of all, this post that starts with page 1828 goes on to the photo of 1829. Do you have a date for the post? Actually, I believe it goes over to, when were these photos posted?
May 3rd, 2016.
Finally, picture of her in the black dress and the post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the Shaver residence, were you involved with contacting Ms. Shaver after the warrant had been completed?
Yes, I was.
And how did you contact her?
By phone.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense would have been previously been marked as states AAA for identification. Showing the witness, states AAA. Do you recognize that?
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Ms. Shaver.
How do you recognize that?
It has my initials on it.
And have you reviewed it and listened to it before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
Fair. At this time, the state moves states AAA into evidence. It's the next numbered exhibit.
Is there any objection?
No objection. Please just object to relevance.
Objection is overruled. States AAA will be admitted into evidence as states number 67.
You're going to ask to publish?
Permission granted.
see what she's doing. This is Laurie. Hey, Laurie, Sheriff from the Sheriff's Office. Hi. I just wanted to call you over to you over property that we are done out here. You guys are welcome to come back anytime. Okay. We locked the doors back up, put the keys and all stones down in the shed back where it belongs, and everything is just ordered. But I do have to real quick, and certain paperwork will be left in the house to include all the items that we took. If you have to, I would like to just run over those listed items real quick with you over the phone later. The items to be
Okay, absolutely.
okay. Total wireless cell phone, swab, micro SD card, green
What's swab? What's swab?
most of swab is going to be stuff that like
Oh, swab, things that you swab. Okay, gotcha.
flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swabs, SD card with photos belonging to like the sheriff's office, possible buckshot TVs, projectiles, unfortunately this is a word that's not read, and human skeletal remains. So as far as all that goes, do you have any questions?
Okay.
Okay.
Do it.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
There was some mention of a computer, some SD cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge.
Mr. Wiggs? Yes, ma'am, please support.
So if you just found out for the first time in your life that they dug a human skeleton out of your backyard, would your response be, okay? Mine wouldn't. I'd have questions. I'd want to know more details. What do you mean you found a human skeleton? Please explain. That response is a little different than what I would expect.
May it please the court.
Yes, sir. Please proceed.
Deputy,
Corporal.
Corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession.
Oh, that's the explanation. We were all just being polite. Laurie was just being polite. That's all. Sure, she was shocked and had questions, but she wanted to be polite.
Of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole.
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any confession of guilt?
No, sir, you do not.
Very well. Thank you.
Thank you. State. All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
State calls Kendall Davidowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Kendall Davidowski, KENDALLDAVIDOWSKI.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know him?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position with Disney?
I was an electrical apprentice at the time. He was a mechanic.
And at the point that you met him, where was he living?
He was living at the Warbirds hangar in Kissimmee.
What is that?
It's a airplane hangar, I mean.
And do you know Laurie Shaver?
I know of her, yes.
And what was, at the time that you met Michael Shaver, well, let me ask you this, at some point did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told.
Based on hearsay?
State response.
Your Honor, can we approach?
Sidebar, please.
Were you aware of the events that led to why Michael Shaver was living in Warrant?
He had told me why he was, yes.
And was that related to his arrest for domestic violence?
Yes, it was.
Now, did he talk, and I'm not going to ask you to say this, what he told you about that event, but did he explain what had happened that night to him?
Yes.
Based on that, did he express fear of Laurie Shaver or his safety?
Yes, he did.
And could you explain that?
He was concerned of his safety and the children's safety with Laurie and a gun.
Laurie, what?
And her having a gun.
Now, did you ever see Michael Shaver interact with his children?
I saw him interact with his son, Aiden, once.
And how was that?
They seemed to get along very well.
And at some point did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of a mutual decision. It was just becoming too much at that point.
And at that point, was he trying to reconcile with Ms. Shaver?
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so I mean, we were cordial, but we didn't speak to each other.
After he went missing, did you make attempts to reach out to him to see where he might be?
Yes, somebody from Spaceship Earth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You had, well, first of all, was that a phone call?
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him in Facebook before?
Previously, before May, yes.
And when you guys were dating, did you also exchange text messages?
Yes.
Was there anything unusual about the contact that you had with him and the content of it?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers, so that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further, Judge.
Mr. Wiggs?
Yes.
You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're sexually harassing people?
Supposedly, yes, according to Disney.
How long did you date Michael?
From about, I would say December of 2015, December 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any physical? Did he show you any photos of any battered women?
No.
Did he show you any police reports involving Michael Shaver? Okay. Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies?
No.
You know who killed Michael Shaver?
I do not.
Thank you.
Redirect.
Ms. Davidowski, Was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Okay. Nothing further, Judge.
Any follow-up?
No follow-up.
Thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Robert Sellers.
Wait a minute. Laurie Shaver filed a sexual harassment claim against somebody who was in an inferior position, so to her husband at her husband's job. So her husband was kind of, even if he wasn't a direct superior to her, he was kind of above her as far as positions are concerned on the ladder at Disney. And Laurie Shaver filed a sexual harassment claim against Kendall. And now the defense is coming into court saying somebody filed a sexual harassment claim against Michael. I am so confused. He's trying to convince the jury somebody filed sexual harassment against Michael when it was his client that filed a claim against the lady that Michael was having an affair with.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
I'm ready, sir.
All right, please state and spell your full legal name.
Robert Sellers, R-O-B-E-R-T, last name Sellers, S-E-L-L-E-R-S.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name's Rob Sellers. I'm currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
In 2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what will your duties be as someone on road patrol?
I'm his road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September 2014?
Yes, sir, I did.
Were you the arresting officer of Michael Shaver from the domestic violence incident that has been discussed in this case?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael Shaver?
I did. I spoke with Laurie first and then ended up making contact with Michael a little bit later on.
Is it fair to say that their stories contradict?
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael Shaver, along with some things that happened, conditions within the house?
Yes, sir. I believe Deputy Suttles took those photos.
I'm showing defense, which has been previously marked as states QQQ.
All right, sidebar, please.
So the last witness's testimony, Kendall's testimony, makes the defense look really bad because the jury all this time has probably been thinking that there's this sexual harassment claim in addition to whatever, domestic violence was occurring. To find out that the guy who is trying to convince them that there was this sexual harassment claim is defending the person who filed the sexual harassment claim, and he either doesn't know it or doesn't care to tell the jury about it, it seems like would destroy the attorney's credibility and the defendant's credibility. I don't understand that strategy. If you know that somebody can come into court and refute the argument you've been making all this time, why would you make the argument? It's mind-boggling to me.
Witness, what's been labeled as states QQQ. Do you recognize those photos?
Yes, sir, I do.
And what are those photos?
Those are photos that were taken the night of September 4th when we responded to, I guess the first couple photos are from when we met Laurie Shaver in the Target parking lot in Claremont, and then the last couple photos appear to be when we met Mr. Shaver at the residence, and photos of the residence itself in Claremont.
Do they fairly and accurately depict the things that you had photographed as part of your investigation in this case back in 2014?
Yes, sir, they do.
The state moves to states Q evidence is the next numbered exhibit.
All right, Mr. Wiggs? Without objection. Without objection, states QQQ will be entered into evidence of states number 68.
I'm going to go ahead and publish. This photo number 1 from states QQQ. Who is that?
That's Laurie Shaver.
Photo number 2. What does this photo depict?
The photo of her left arm,
Photo number 3.
her right arm.
And photo number 4. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number 5. Does that demonstrate that laceration?
That would be the laceration, yes, sir.
And photograph number 6. What is depicted here?
Their residence.
Photograph number 7. What is shown in this photograph?
Broken door to their residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number 8. What is that photograph?
I believe it's the other side of the same door.
Photograph 9.
2 firearms that were involved in the altercation.
Photograph 10.
Be the bathroom.
Was that all the various areas of damage that occurred?
Yes.
That you took photographs of?
To the best of my recollection, yes, sir.
There's also some sort of indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
belonged with the slide glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver didn't know.
No, it's not that I recall.
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they fought over the pistol, and while they were fighting over the pistol, it somehow went up and struck him in the head.
Did Mr. Shaver have a contradictory version of that?
He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any of the children in this case, specifically the oldest child, Isabel Shaver?
All right, so refresher. Robert Mercado came in. He was witness number 5 for the prosecution, and he said that he's the one that took Michael Shaver to the airport hangar after having taken him to the house to get his belongings that he was going to be taking with him. And he said that he was present for an incident that occurred during that visit. He said that there were guns involved. He had to get in between Laurie and Michael in order to prevent any further violence. But he made it clear there were guns involved and that Laurie had one, at least one. Laurie came in yesterday and told us all that Robert Mercado is a liar. The incident in 2014 did not involve a gun at all. Now we've got an FBI agent, somebody who doesn't even work for the LCSO anymore. He probably couldn't care less what happens in this case from a personal standpoint. Obviously, he wants to see justice done, but he doesn't have a vested interest in this case. He's an FBI agent. He used to work for LCSO, and he's telling us that there were 2 firearms involved in that incident. So Robert Mercado was not lying, and obviously Laurie was.
There was, yes, sir.
Was she able to tell you anything about that?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
Can we move this next, Madam Bailiff?
Sorry. I'm receiving a call now. I apologize.
I'm sorry, what do you, may it please the court?
Yes, sir.
What do you go by now? What's your,
I go by Rob, but my legal name's Robert. Yes, sir.
okay, I know you're with the FBI now.
Yes, sir.
What's your title over there?
Special agent with the
Special agent, okay. What do you want me to call you? Special agent? Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
All right, redirect.
No, sir.
All right, thank you for appearing today. You're released from further testimony, and have a good day.
Thank you, sir.
Yes, sir.
State calls Wilman Nicholas.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Wilma Nicholas, Wilma.
This is the neighbor. I wonder if they're going to ask, did you hear any gunshots go off in May of 2016?
Nicholas.
And please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please proceed.
Please reintroduce yourself to the jury.
Hi, I'm Wilma.
Now, in September of 2014, was there a disturbance at your neighbor's house, the Shavers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries to him?
Yes.
What was his demeanor? Was any, that he said distraught, anything?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Was he still troubled by whatever caused his injuries and things of that nature?
Not so much of his injuries as something else.
Just for the record, I'm going to object on Williams' basis, under the Williams rule, the matters that we previously addressed at the court.
Yes, sir. State.
Can we approach?
Yes, let's have a sidebar. Thank you.
Everyone, I plead ignorance. I don't know what the Williams rule is, so I can't offer any insight.
What did he describe? So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes.
What did he describe to you that happened?
He told me that they had an argument. Laurie was intoxicated and she had taken off with the kids. The injuries that I saw on him, he said that she had threatened to kill the children, him and herself, and he fought her with the gun and was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes.
Did you take pictures of those injuries?
I did.
Showing the defense what has been previously marked for identification as states 000. Showing the witness states 000. Do you recognize these photos?
Yes.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after you described the events that you've talked about?
Yes.
This time the state moves states 000 into evidence. That's the next numbered exhibit.
Mr. Wiggs, any objection?
Same objection, Judge Standing.
Objections overruled. States 000 will be admitted into evidence as states number 69.
The time frame that you knew Mr. Shaver, what was his approximately height and weight?
He was about 5'6", almost the same height, I think, as me, and about 150 pounds.
I'm going to go ahead and publish photograph number 1 from the previous exhibit. What were you trying to show with this photo? Can you see it?
Barely.
Let me turn it.
Okay, you can tell that he has blood coming from the top of his head, and then it's come down onto his shirt. His shirt has been torn in multiple areas here in that photo.
And the tearing of the shirt, did he attribute that to Laurie Shaver?
Yes.
Photograph number 2.
Here you can see the top of his head and the injury a little bit better here.
Did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket, and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further, Judge.
All right, Mr. Wiggs.
Please, the court.
Yes, sir.
Do you know who was charged out of this incident?
So remember yesterday, Laurie said he was trying to prevent her from leaving the house, and she made it seem as if he was trying to prevent her to leave from leaving because he was so possessive and so controlling. According to this witness, Michael said it wasn't about being controlling. It was about trying to protect his wife and his children, as his wife was trying to flee the house in a drunken state, and he did not want her to leave with his kids driving drunk.
With any criminal offense?
Yes,
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes,
And Michael ends up being prosecuted, correct?
he does.
Okay. So you would agree the state attorney's office had a different opinion.
Objection, Your Honor. Charging decisions of the state.
Sustained.
So evidently people were dealing with Michael Shaver. Michael Shaver ends up prosecuted, correct?
Based upon,
Ma'am?
yeah,
Correct?
yes,
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes,
Okay. Did you interview Laurie Shaver?
no,
Okay. Do you know who the initial aggressor was that caused that injury?
Yesterday, we got a one-sided version from Laurie, and he didn't seem to have a problem with it at all. We can't ask Mike what happened, obviously. So who else are we supposed to ask? She was the person that showed up right after Mike left. Who is the prosecution supposed to ask?
To Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
All right, redirect.
Yes, sir.
All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Rebecca Urbanowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed. Thank you. All set? All right. Please state and spell your full legal name.
It's Rebecca Urbanowski, REBEKAHURBANOWSKI.
All right. Thank you. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
And do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And you work for the gym?
Yes, Gold's Gym in Claremont.
And what position do you have there?
I was a personal trainer there.
And when you say her boyfriend at the time, who is that?
Jeremy Townsend.
The did you ultimately start a professional client-trainer relationship where you were training her?
Yes, I did.
And what was her general physical status at that point?
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know Travis Filmer?
Yes, I do.
How do you know Travis?
That is my brother-in-law now.
Who's your husband?
My husband is Austin Filmer.
And when did you get married to Austin?
October 28th, 2016.
Now, did you legally take his last name?
I did not.
So on your driver's license it says Rebecca Urbanowski?
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you had the Filmer last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be a correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Filmer?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they start hanging out?
They met the first time at the end of February of 2016.
And when was this compared to when she was dating Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date, and both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he'd already had a girlfriend at the time. He didn't want it to look like a double date, so they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came into the picture, did they kind of overlap? What was the deal there?
They kind of felt like they overlapped, so it was kind of a gray area where when one stopped and then the other one officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct, yeah.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there one time when I was there, but I hadn't moved in at that point.
And like, what kind of day are we talking about when Jeremy would come over?
It was during the afternoon time.
Around your lunch break?
Yeah, I would say so, yeah.
And while you were living there, did you see Laurie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed,
Okay.
yeah.
Now, during the time that you were friends with Laurie Shaver, was a concrete slab put in the backyard around a fire pit?
Not when I initially moved in, no.
But were you friends with her, socializing with her when that occurred?
Oh, yeah, sorry, yeah.
And were you and Austin present when the cement slab was placed down?
I was actually at work most of the day. When I got back, it was there because I worked majority of the day.
During the time frame that Laurie has been with your brother-in-law, Travis Filmer, has the relationship between Austin and yourself changed with Travis?
Very much so.
Describe.
We rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together.
Did she say that she was living there in May of 2016? Or did he ask? Did she give a time period when she was living there, like a beginning and end date? Because I'd wonder if she saw any evidence of, blood or anything on the back porch, anything that might indicate that something had occurred on the back porch in May of 2016.
They used to go fishing a lot, hanging out, but we don't see anything from him, or we don't talk to him. We don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
Did Laurie Shaver ever tell you what happened to her prior husband, Michael Shaver?
Just that he had left.
Nothing further.
Mr. Wicks?
So y'all have a bad relationship, correct?
Who?
Austin and Lori and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight? That there's a bad relationship? Bad blood?
I guess.
You lived in the residence in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
Okay. And you know there was, she was dating Jeremy for a period of time, correct?
Yeah, for a little bit.
You have sit-downs with Jeremy?
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it would have been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Lori's wedding, yeah.
So were you back there in the period of time when you was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Lori?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in, what year was that?
That would have been December 31st, 2016, sorry.
And had that been you were a guest at that?
Yeah, because the next day, we were moving into, Austin and I and Kendall were moving into our new home.
Had that event been represented to you to in fact be a wedding?
Yes, it was.
And she was in a white dress?
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
There was wedding cake?
There was a wedding cake, yep, a dress.
Everyone there thought that Travis and Lori were being married at that time?
For sure.
Nothing further.
All right, Mr. Wicks?
Nothing.
Nothing. All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Christina Vasquez.
So she moved in May of 2016 and moved out January 1st of 2017. Laurie Shaver was asked directly by the plaintiff when the incident occurred, and she said it occurred in the beginning of May of 2016. So theoretically, the incident could have occurred in the beginning of May 2016, and Ms. Urbanowski moved in anytime after that, and she would not have seen any evidence of any crime taking place, anybody being killed. The other interesting thing she said is that she saw Jeremy at the house once. We don't know if she was living there when she saw Jeremy at the house, or if she saw Jeremy at the house sometime before she was living there, but she saw Jeremy once. If it was while she was living there, that means Jeremy came to the house either in May or sometime after May. We just don't know, and the prosecution didn't really clear that up for us.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Katina Vasquez, Katina V as in Victor, Asquez.
Please raise your right hand. I'll swear you in.
So I earlier said that it was Rebecca Urbanowski who had talked to Robert Mercado and indicated that there was and given him some reason to call the police department. It was not Rebecca Urbanowski. And looking back at my notes, it was actually this witness, Scott Amatuccio. Scott Amatuccio testified that it was a conversation that he had with Katina that led him to call Michael's sister and let Michael's sister know that he was going to call the police based on something that Katina told him during that conversation. So maybe we will find out what that was now.
Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Yes, okay. Thank you. Please proceed.
Please introduce yourself to the jury.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
I do see her here in the courtroom today and identify by something that she's wearing.
A black jacket.
And how did you meet Laurie Shaver?
Through Scott Amatuscio, my ex-fiance.
And do you remember approximately what year you would have met Laurie Shaver?
I believe we started dating 2006, 2007, and we ended the December 2014.
And did you know Michael Shaver?
Yes, sir.
And how did you meet him?
Through Scott.
And were Scott and Michael Shaver close friends?
Yes.
What was your, through meeting Laurie through her friend Mike, did you develop a friendship with her?
Yes, sir.
Did you develop a friendship with Michael Shaver?
Yes, sir.
Closer friends with her than Mike?
Yeah.
And did you ever go over to the Shaver residence after Mike disappeared in November of 2015?
Yes, sir.
And why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working there?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going to work for them? You don't remember anything about that? Mm-hmm. Okay. While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in she was on the porch on the phone, and I went to the bathroom, and like all his stuff was like still in the closet and stuff, and the car was there.
Talk about clothes, toiletries, things of that nature? Is that yes?
Yes.
Okay. Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
Yes.
And what was that?
She was on the back porch on the phone and was trying to sell guns, and I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
Now, were you familiar with a domestic violence case where Mike Shaver was arrested in 2014?
Yes, sir.
And how did you become familiar with that?
Laurie told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport, and she said that, and I was kind of like, why is he here, kind of, and she said that she was working with being honest with her therapist, and that Mike didn't touch her, like all the wounds were from her. She threw a vase and broke a door. It wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
When did your friendship with Laurie Shaver end?
2017.
And at the time, in 2017, when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare, and she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot. And she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her?
Yes.
So clearly after May of 2016?
Yes.
And clearly after September of 2016 when the cement slab was put in her backyard?
Yes.
Nothing further?
Mr. Lakes?
Please support.
Yes, sir.
Ma'am, did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
No.
Did Michael ever obstruct your relationship with Laurie?
Is the defense attorney, is Mr. Wiggs intentionally trying to plant doubt in the jurors' minds by bringing up documents that don't actually exist? So this is at least the third time that he has asked a witness about a document that he did not produce to the witness, did not show to the witness, and the witness denied knowledge of. So I'm wondering, if you're asking a witness a question about a document, typically you know that that document exists, and the way that you know it exists is because you have a copy of it, and you're essentially trying to catch the witness in a lie. He's asking her, did she sign off on this on a document submitted to the Department of Children and Families or something of that nature? And so in the juror's head, the answer to that question then is going to be yes. When she says no, they expect him to pull out the document and say, let me refresh your recollection. He's not doing that. This doesn't see. So I can't, my ethical duties restrict me from using that as a tactic. I essentially can't, I would be defrauding the jurors, which are members of the court. So I'd be defrauding the court if I am intentionally trying to make them believe that a document exists, believe that a witness signed off on a document that I know they didn't sign off on. That would be defrauding the court. And I am restricted from doing that, even through my questions. I can't just get up there and ask questions about things I know don't exist. I know have no relevance. I know are not pertinent to this case, and would, in the minds of jurors and or the judge, give them a false impression that these things exist. I can't do that. I don't know if that is the tactic he's taking, but it's beginning to sound like it, just based on the number of times it has occurred in this trial.
No.
Okay. Now, when you said that Laurie was selling property out of the residence, do you have any understanding whether that was only Michael's property or whether it was marital property? That she was by law prohibited in any manner?
She just said the guns, and I know the guns were theirs. And
okay. Do you know anything about marital labor and contribution to the marriage?
No.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
They were their guns. He built and restored guns, so.
Do you know why the property was being sold?
No.
Do you know if it was maybe the need for groceries and necessities?
No.
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime?
No.
Did you ever witness a murder or any event occur at the house?
No.
So
now the event that you spoke about
he's asking about her selling off his guns and things of that nature to purchase food. My understanding was that she had an order from a court, or she testified that she had reached an agreement in some administrative action or court action whereby he would be paying support. So if she expected him to pay support, why would she immediately start selling off his property as if the support wasn't coming, unless she knew the support wasn't going to come because he was no longer alive?
an incident that occurred at the house, a crime, a battery? Were you there to witness that event?
No, sir.
Correct. Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good day. Next witness.
At this time, the state of Florida rests.
All right, let's take the jurors out at this point. Have a comfort break.
So we may get some argument here. I don't want to miss any argument that happens.
Jurors have exited the courtroom. Are there any motions at this time?
Yes, Judge, we renew our motion for judgment of acquittal on same grounds previously stated. We'd also make clear that these acts of violence that have been spoken of have been only offered for prejudicial value against the defendant. There's no probative value. There's no notice. It's not substantive evidence established to prove a prima facie case. It's purely circumstantial. The state supplied the court with case law. In that case law, there's a notation to a 5th DCA decision speaking about any relative probative value can be outweighed by the substantial prejudice that it presents. It should not have been.
So let me just remind everybody how this happened. So the prosecution got up, they gave their case in chief. We didn't hear about domestic violence at all. They very much left the domestic violence piece alone and let the defense put on evidence of any domestic violence. At the very least, at the point that Laurie got up there and started talking, she was telling us all about all the domestic violence that she had experienced, right? We heard it repeatedly. Then the prosecution got back up and put all of that domestic violence in context for us. So, his motion saying that the prosecution somehow did something wrong by introducing evidence of this domestic violence and it has no probative value, this, that, and the other. They only introduced that so that the jury would understand this wasn't necessarily Laurie committing Michael committing acts of domestic violence against Laurie. Perhaps he was, but let's hear from these other people who are going to testify and say, no, this was Laurie. Even her friend Laurie said all of that stuff that I put in that affidavit that I submitted to the police department was false. It was all me in September of 2014. You know, that time that he got arrested, that was all me. I had the gun. I was threatening to kill myself. So the prosecution is allowed to put that into evidence because the defense opened the door for it. So I don't think this motion is going anywhere.
Have been presented to the jury. The digital data that the state relies on is not sufficient to establish causation. It does not establish the nature of the offense. It does not defeat a claim of self-defense. There's been reference to sale of guns. There's no distinguishing that this is non-marital funds, that Ms. Shaver had no right to sell this property, nor does it advance any claim to an accessory after the fact. We'd ask that the court grant a judgment of acquittal on these grounds and all other arguments previously mentioned before the court.
All right, thank you, Mr. Wiggs. State's response?
The state most favorable to the light most favorable to the state. There's sufficient evidence to present to the jury.
Motion is respectfully denied. When viewed in a light most favorable to the state, the evidence does establish a prima facie case sufficient to support conviction as to each count in the information. Motion is respectfully denied. All right. And anything further, Mr. Wiggs?
1 second.
Yes, sir.
So that motion was denied. This judge has a very good demeanor.
Thank you, Judge.
Thank you, sir. No rebuttal from the defense. How long will the state take to print out the revised jury instructions?
He's been very good about letting the attorneys say their piece, establish the record, do everything that they need to do. He already knows how he's going to decide on these things. And to the extent that there were contemporaneous objections, those objections that occurred during the witness testimony, he made sure to disassociate the jurors from those objections. There were those moments when the defense attorney would begin making speaking objections and he would cut the defense attorney off and say, just come up here, because the jury is not supposed to hear those. You don't always find a judge that does that. Sometimes they let those speaking objections go on too long. This judge hasn't done that. I think this judge has handled this case really well. He may have made some evidentiary errors regarding his rulings. Even if he did, I don't think that any of them are are harmful to the prosecution's case in that they will result in a victorious appeal should the defendant be convicted in this case.
I have a couple questions for clarification. They're done, Your Honor?
Yes, sir.
Some answers from Mr. Whitman on a few things. The forcible felonies in self.
So these are jury question things, jury instruction things. They're going to read the jury instructions. So again, we won't waste time listening to the questions that they have about jury instructions. Let's just get back to the case. Well, we're probably going into closing arguments at this point. Actually, we may still be dealing with jury instructions.
Have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Lee Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Lee Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes a lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael D. Shaver was killed by Laurie Lee Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Lee Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder, second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of Laurie Lee Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Laurie Lee Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Lee Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her guilty of second-degree murder. Possession of a...
You should not find her.
Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. Possession of a firearm and discharge causing great bodily harm or death. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including the starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant, A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Michael D. Shaver is dead. 2. Laurie Lee Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Lee Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Lee Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following four elements beyond a reasonable doubt. Number 1, a murder in the second degree was committed by another. 2, after the murder in the second degree was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at the time Laurie Lee Shaver knew that other person had committed Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4, Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact of second-degree murder is accessory after the fact of manslaughter. Accessory after the fact of manslaughter. To prove the crime of accessory after the fact of manslaughter, the state must prove the following four elements beyond a reasonable doubt. Number 1, a manslaughter was committed by another. 2, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. 4. Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Justifiable use of deadly force. It is a defense of the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1. Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2. Michael D. Shaver acted with a premeditated design to kill Laurie Shaver. 3. The act would have resulted in the death of Laurie Shaver except that someone prevented Michael Shaver from killing Laurie Shaver or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will or intentionally caused bodily harm to Laurie Shaver. 2. Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm, and after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another, or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, she must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if: A. The person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, Laurie Shaver or Isabel Shaver knew or had reason to believe that an unlawful enforceable entry or unlawful enforceable act was occurring or had occurred. Presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C, the person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she or another was in danger of death or great bodily harm at the hands of Michael D. Shaver, you may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Parties have anything further? State? Yeah, come on up, please.
So we got the jury instructions. We're about to go to lunch. See if there's any argument before lunch. Doesn't look like it. So let's see if they are done with lunch. And they are not. It looks like they're going to be gone for at least another 25 minutes. They'll probably come back very close to that time, if not that time. So I am going to, decisions. Do I just keep the live going or do I start a new one? Tell you what, we'll start a new one at 12:45. So I will put up a thumbnail for that right now. And if you all want to jump into that one at about 12:45, I'd love to see you all there so we can all listen to closing arguments together. I'm going to go grab a bite to eat because I'm hungry and I don't have much time to do it. So you all get your popcorn. I'm going to go get some food and I'm not going to chomp in you all's ear. So I'm going to eat quickly. I will see you all back here hopefully at 12:45. Thanks for coming. My name is Nathan Saunders. And as you know, this is The Legal Good.